Thank you very much to our three co-sponsors today, the Genocide Studies Program, the Schell Center, and the Council on African Studies. I also want to give a special thanks to Jim Silk and to David Simon. I spent exactly half of the last 18 years here at Yale, and both of them have been such cherished mentors to me. So I'm so deeply grateful to both of them. Thank you. Today I'm going to talk about the legacies. I'm going to continue the conversation of the legacies of the international legacies of the genocide, but I'm going to focus specifically on justice and law issues. I'll start by talking a little bit about the causes of the genocide and how those relate to the consequences. I'll then review the main transitional justice mechanisms that were instituted, and then I'll talk about the legacies of those institutions. So this is an overwhelming slide, and it's meant to be there were so many numerous causes of the genocide, from the racial superiority theories to discrimination that really plagued the Rwandan society against Tutsi, severe poverty, overpopulation. But it really was a single factor that perhaps really catalyzed the genocide. There was a culture of impunity and immunity, being sort of separate things, that was born from the historically unaddressed atrocities. There had been atrocities dating back half a century before the genocide in '94 even erupted, and various scholars and officials even categorize some of these as genocides as well, especially in 1959 and 1963. There has yet to be a legal determination that any of these events were genocide, but it's very clear that mass atrocities have been committed against Tutsi for about 50 years in Rwanda. And so what did this lead to? The official responses was that nothing would be done to the Hutu who had been involved in massacring the Tutsi. And not only that, but the Rwandan government at the time even took a further step. It actually instituted a series of legislations of impunity to immunize the perpetrators of these atrocities. And so the signals to the Hutu extremists were twofold. One was that you could practice and even refine your ability to kill en masse, at least the Tutsi. And then the second was that they learned that they could commit with impunity, that simply nothing would be done if Tutsi were killed. This then led in '94, after the genocide against the Tutsi, the massive genocide against the Tutsi was perpetrated, to a number of questions. Should this now be a time where the génocidaires, the genocide perpetrators, should finally be brought to justice? And if so, how, when, where, and who among them? Some estimates were that there were possibly as many perpetrators as victims. And if that's the case, there was an enormous number of perpetrators who very well could be held accountable. There were essentially four main transitional justice mechanisms that were instituted during and after the genocide. The conversations, the decision-making process actually started even during the genocide. So there were two outside of Rwanda. One was judicial procedures instituted through the UN International Criminal Tribunal for Rwanda, the ICTR. And that involved two different aspects. One was prosecutions by the tribunal itself, and the other was transfers from the tribunal to other jurisdictions. The second main institution outside of Rwanda were judicial procedures by foreign countries. And again, there were two elements to this. One were prosecutions that the foreign countries themselves would implement, and the second were extraditions or deportations of suspects to other jurisdictions. And I'll talk more about those in a minute. Then there were two main mechanisms within Rwanda itself. One was the prosecutions by the ordinary domestic courts, and the final one were prosecutions by Gacaca, which we'll be discussing more. So the Rwanda Tribunal was established in November of 1994. It was established by UN Resolution 955, and then a few months later, the location, the seat of the tribunal was established through Security Council Resolution 977. It was decided it would be placed in Arusha, Tanzania. The consideration was that Rwanda itself was too unstable in the immediate aftermath of the genocide to house the tribunal. The outcomes to date, and this is based on the most recent report from the tribunal, are that all trial-level cases have now been completed. So there have been about a little over 90 accused individuals for whom trials have been completed. There have been appellate-level judgments delivered against 46 of those individuals. The tribunal has now also taken the step of referring some of the outstanding cases to national jurisdictions, a few to France, some to Rwanda itself, and some fugitives. So those still have yet to be apprehended, also to Rwanda. There's now also a residual mechanism that's been instituted for both the Yugoslav and the Rwanda tribunals. And that's assumed the responsibility for trying even more cases. So in some ways, it's really just a continuation of the tribunal itself. The tribunal also withdrew a few indictments, two. Some of the indictees had died either before or during their trials. And the tribunal projects that it'll complete all of its work by July of 2015. Given that it was instituted in November of 1994, that'll be 21 years. As for the foreign countries who have been involved, this has been predicated on basically two different mechanisms. One is a claim to universal jurisdiction, the idea that some offenses are so heinous that any country in the world can and should be able to bring cases against their perpetrators in their courts. It's a controversial claim, which we'll discuss more in a moment. And then there's also been the introduction of various laws locally, domestically, that have enabled these prosecutions. So I've listed here the 10 or so countries that have already brought cases or are considering bringing cases. France is one to point out for just a moment, as lots of suspected genocidaires have sought refuge in France, and it was only until very recently that France has been willing to bring a case against them. As for the foreign countries extraditing or deporting, I thought I would give you two examples from our country. So an extradition to the ICTR, one example comes from 2000, where Elizafan and Takirutimana had been seeking refuge in Laredo, Texas. He was the very first person who was extradited from our country to an international tribunal. There have also been deportations, or there are considered deportations to Rwanda, the most recent of which is a conviction in New Hampshire of Beatrice Munyanyenzi for lying on her passport. So one of the mechanisms or the strategies through which the American justice system will pursue genocide offenders on our soil is to catch them lying on their immigration forms about what they were doing before they got here. And if indeed you're caught lying, there's punishment here in the United States, and then the possibility of extradition or deportation to Rwanda, which very well may happen in the case of her. Moving on to Rwanda, there was a recognition very early on, even in the process of setting up the ICTR, that the ICTR was never intended to process the overwhelming number of genocide perpetrators. And so the preamble, as I note here, even includes this recognition, this acknowledgement that part of international cooperation should be focused on strengthening the capacity of the Rwandan courts themselves to deal with this huge caseload. Rwanda had acceded to the Genocide Convention, which obligates its members or its signatories to prosecute or to prevent and punish the crime of genocide. They acceded to this treaty in the 70s, but it wasn't until 96, 20 years later, that legislation was introduced to actually make them capable of dealing with these cases. So the relevant organic law, was introduced in September of 96. And then the first case was initiated a couple months later in December. Now that brings us to Gacaca, which in many ways is the most innovative and widespread of the transitional justice mechanisms that have been instituted to deal with the Rwandan genocide. Gacaca itself in Kinyarwanda, the indigenous language, means the grass or the lawn. And basically it was introduced out of this idea that there's a necessity to somehow deal with this enormous number. Even if the ICTR was going to deal with just a few dozen, maybe 70 or so, and the national courts, the ordinary courts, were going to deal with a few thousand, that still left hundreds of thousands of cases still to be dealt with. And so essentially this Gacaca system, which had been a traditional conflict resolution system in Rwanda, was resurrected, was revived, and it was modified, it was revised to deal specifically with genocide crimes. In 2001, the relevant legislation was introduced, establishing these, what was known as Gacaca jurisdictions. And at that time, 4 categories were established that would delineate what crimes you were suspected of and where that would then indicate you would be prosecuted. The most egregious offenders, the real masterminds, would be dealt with through the ordinary courts, but that would leave those who had attempted murder, who had committed property crimes to be dealt with through Gacaca. This legislation has been modified several times, 01, 04, 06, 07, 08. And in part to streamline the process, and in doing so, it collapsed categories 2 and 3 into one, moved category 4 to category 3, and left category 1 to be dealt with through the ordinary courts, and now categories 2 through 3 would be dealt with through Gacaca. One of the really amazing things about Gacaca is the number of participants in it. And so in 2001, 260,000 judges were elected locally. And this represents about 6% of the entire Rwandan population at the time was elected to oversee, to participate in adjudicating Gacaca. And also as part of the Gacaca process, also to deal with the enormity of the caseload, the Rwandan government began provisionally releasing detained individuals in the tens of thousands, as you can see. The Gacaca process lasted exactly 10 years, from 02 to 12, and I thought I would provide you the really staggering statistics of how many cases have been dealt with. So it tried almost 2 million cases. It convicted 86% of the individuals involved in those cases, and acquitted 14%. And then heard appeals from about 9%, affirming 74% of them, reversing 26%. And then if you look at these statistics a different way, if you look at them in terms of the suspects instead of the cases, and the reason why you need to look at them separately is because some individuals committed lots of crimes, so led to multiple cases, and some individuals banded together in groups and committed individual crimes for a single case. And so if we look at the numbers that way, it tried over 1 million people, and most of whom, the overwhelming majority, were men. So I thought I would talk a little bit now about the legacies that we then take from these 4 transitional justice mechanisms. One, at the level of Rwanda, concerns the death penalty. So President Kagame at one point says the government could not become a mass executioner in order to correct mass murders. And the criticism at the time and the concern was that if indeed Rwanda followed through on capital punishment for these genocide crimes, you would have massive death penalties. And of course, this would be for a different reason, but the optics and also just the overall logistics were greatly concerned a lot of people. The second sort of concern about the death penalty was that this was really an obstacle for transferring cases from the tribunal and from foreign jurisdictions. The rules of procedure and evidence of the Rwanda tribunal itself dictates that cases cannot be transferred to any jurisdictions that implement the death penalty. So the part of the legacy is that the Rwandan government decided to abolish the death penalty in 2007. By that time, it had actually been several years since any death penalty had actually been even carried out. And in some ways, this really contributed to the overall campaign, the global campaign, to abolish the death penalty. For third-party states, for foreign countries, there are a number of legacies as well. One concerns universal jurisdiction, which I mentioned before. Even though it's a very controversial claim, legally as well as politically, some aspire to this idea that really, when it comes to genocide and other atrocity crimes, these should concern us so much that they really ought to be dealt with anywhere. This has been implemented to varying degrees in different countries and has also received a lot of pushback for various reasons. There's also been incorporation of atrocity laws, enabling legislation in various domestic and national jurisdictions that allows domestic polities, domestic countries, jurisdictions, courts to prosecute for atrocities. And then another legacy is that, as we know, the new now permanent War Crimes Tribunal, the International Criminal Court with potentially unlimited jurisdiction globally, has been signed by over 100 countries all over the world. There have been other legacies also internationally from the International Criminal Tribunal for Rwanda itself. So three just to point out, because there's such precedent-setting significant legacies, are that the ICTR had the first conviction of a former head of government in the form of Prime Minister Jean Kambanda. The second was that it's the very first international tribunal to define rape and sexual violence, and that it could constitute genocide. And this was in the case of Akayezu. And then also significantly, the tribunal determined that mere speech, which had been such a component to both inciting as well as orchestrating the genocide itself, mere speech could also constitute genocide, genocidal incitement. And that was in the famous media trial. As for Rwanda, the recognition, the legacy here is that there is a need, often, even if international mechanisms are constituted, and even if there's a domestic infrastructure available for additional transitional justice systems. In this case, it was in the form of gacaca, and these can be done sequentially or simultaneously alongside the other existing transitional justice mechanisms. The scale and the significance of gacaca cannot be understated. Nearly every single Rwandan adult has been involved in gacaca. It's now a population, the country has a population of about 11 million people. This is a staggering statistic. And they've been, involved as judges, as witnesses, as defendants. And that's led some people, like my colleague Phil Clark, to describe gacaca as the most comprehensive post-conflict justice program attempted anywhere in the world. And there are various other sites of atrocities that are looking now to gacaca as a possible model for indigenous transitional justice. As for the legacies from the international side, the establishment of the ICTR itself was precedent-making. It really affirmed the role and the power, the authority, which had been established during the establishment of the creation of the Yugoslav Tribunal the previous year, of the Security Council to create these ad hoc tribunals. But in the case of the ICTR, this was the very first time that such a tribunal had been created for a purely civil conflict, establishing the precedent for even internal crimes, which relates to, I think, the R2P concept. It's now led also to the proliferation of tribunals in various countries around the world and for various scenarios: Sierra Leone, Cambodia, Iraq, Lebanon, and also the creation of the new permanent International Criminal Court. One of the things I should point out is, in my research, this has been very evident that there's a significant amount of path dependence which relates to the design and whether or not to even create a transitional justice mechanism in the first place. The ICTR, from what I can conclude, was largely created because the ICTY had recently been created. And as we look at whether and then how tribunals and other transitional justice mechanisms are created around the world, it is vital to look at what already exists and what comes before it. In many ways, they're used exactly as models for what comes later. Some of the individual legacies that derive from the ICTR include that the prosecutor, there was a shared prosecutor of the ICTY and the ICTR initially, and basically the reason was because it would have been so difficult to find a suitable candidate in the case of the ICTY. That person, in the form of Justice Goldstone from South Africa, was then just sort of had an expanded mandate to include Rwanda. But the problem was that the people who had served in his, and who later served in his capacity, in his position as chief prosecutor of the shared tribunals, spent very little time focused on Rwanda. Some estimates are that in some years as little as 35 days were spent actually in Arusha at the other tribunal. This led to lots of management problems. And so the legacies from that were included that the tribunal itself separated, the tribunals had a separated, the Security Council separated the prosecutor for each of the tribunals in 2003, and then each subsequent tribunal that has been created has had its own prosecutor, its own chief prosecutor, with a recognition that the attention that individual can focus is required. There have been lots of concerns and criticisms of the speed with which the ICTR has been conducting its work. I just mentioned that itself, the tribunal itself doesn't projects that its work will not be completed until next year, meaning that it will be 21 years. And so the concern is that this is really an unjustifiable delay in bringing to justice these perpetrators. Now that we have a permanent ICC, and part of the rationale for even creating that in the first place was that you would have a standing mechanism that was able to dispense justice a lot more quickly, avoid the delays incurred in starting up a new institution each time you had an atrocity. There have also been concerns about the cost of the tribunal. It has now cost over $1 billion to run. It's an astronomical figure, when we think about it. And so the criticisms are that this has just been unjustifiably expensive. Again, part of the impetus for the ICC was that you would start consolidating cases into a single institution. And hopefully, reduce the costs. Also, the hybrid tribunals that have been created for Sierra Leone and Cambodia have also been designed in ways with cost in mind. More criticisms that lead to further legacies are that too few cases have come before the ICTR, the Rwanda Tribunal. And so what we've now sort of recognized is that we need these simultaneous and sequential transitional justice mechanisms. And also that the hybrid tribunals for Sierra Leone and Cambodia actually included as part of their mandates to much more closely work with the local jurisdictions in order to develop their capacities to process cases as well. Further criticisms include that there's been too little participation by Rwandans in the ICTR. It hasn't reflected their interests or even their laws. And so, yet again, the hybrid tribunals for Sierra Leone and Cambodia in particular were designed precisely to remedy that concern. They include staff from their local jurisdictions and even laws and legal sensibilities as well. The ICTR, as I had mentioned, was created in Arusha outside of Rwanda. This, again, led to further criticisms that too many transitional justice mechanisms are created too far from their sites of atrocities. And so, again, in response, the hybrid tribunals were created on the site of their atrocities. The one for Sierra Leone was created in Sierra Leone. The one for Cambodia was created in Cambodia. However, now there's criticism that the ICC, which is headquartered in The Hague, is now taking a step back. There have been conversations about possibly opening up field offices of the ICC in their sites of investigation and prosecution, but remains to be seen. There's also been these concerns that if you created tribunals, as in the case of Rwanda, ex post facto, you would lose any sort of deterrent effect. And so again, now the ICC, which is a standing permanent mechanism, can be used, hopefully, to promote deterrence. I think are we running out of time then?
Running close to.
Okay, take 2 more minutes. Yet another criticism leading to yet further legacies are that victims have not been sufficiently addressed through the ICTR. there was virtually no consideration for how victims should be dealt with. And in direct response to that criticism, the ICC was designed with that concern in mind, and so now has a trust fund for victims. I think I'll skip further and just mention a few final institutional legacies for the U.S. government itself, and then I'll conclude. So one is that the White House instituted a presidential directive, PDD 10, which actually mentions that genocide prevention should be a core national security interest. And this in many ways owes its genesis in part to the Rwandan genocide, the genocide against the Tutsi. It also has developed various infrastructure in order to try to deal with these situations in the future, and it has a sort of controversial atrocities prevention board, which to many has not dealt with Syria as well as other circumstances sufficiently. There are now other institutions as well. There's now a director on the national security staff who's mandated with focusing on war crimes, a special envoy to the region of concern. The Department of Justice and the Department of State have now also either expanded or repurposed offices to focus on genocide and atrocities. And as been mentioned before, various leaders, various individuals serve in senior capacities now in the Obama administration, invoke Rwanda often in their decision making. Civil society has expanded greatly from in direct response to the Rwandan genocide, which also is yet another legacy that's extremely helpful. That said, I should mention that, as has been said before, it really is political will which remains the elusive legacy of the Rwandan genocide. We can point to various normative developments and even institutional and legal developments as well, but especially as in the case of Syria, we see dithering. And it remains to be seen, I think, whether the call to never again will really mean anything or whether we'll just keep saying it again and again. So thank you very much.